The day I realized I'd made a terrible mistake moving into Pinewood Heights in Rochester, Minnesota, was the same day Brenda Patterson knocked on my door holding a laminated copy of the HOA bylaws and wearing a smile that could curdle milk. I had just finished shoveling the snow from my own driveway when she appeared, her perfectly styled blonde hair somehow immune to the bitter January wind. "Vincent Zimmerman, isn't it?" she asked, though we both knew she'd memorized every detail about me before I'd even signed the closing papers. "I'm Brenda, the HOA president. We need to discuss your responsibilities regarding the community walkways." I wiped the sweat from my forehead despite the 15-degree weather. "Nice to meet you. What about the walkways?" "According to Section 7, Paragraph 3 of our bylaws," she said, flipping to a highlighted page, "your property borders the Eastern Community Walkway. You're responsible for snow and ice removal within 48 hours of any precipitation event." I looked past her at the shared walkway that ran between my property line and the community park. I wasn't aware of that. The disclosure documents didn't mention anything specific about walkway maintenance. Her smile tightened. "It's all in the bylaws you received at closing. I'll expect the ice removed by tomorrow morning. We've already had 2 residents express concern about slipping hazards. That should have been my first warning sign. But I was new to the neighborhood, trying to be a good neighbor, so I nodded and agreed." After she left, I spent 3 hours chipping away at the ice that had accumulated on that walkway, a stretch that ran about 100 feet along my property. The temperature had fluctuated over the past week, creating layers of ice that required serious effort to remove. The next morning, Brenda was back, this time with her clipboard. She inspected my work like a drill sergeant examining a barracks. "There's still some ice near the drainage grate," she said, pointing with her pen. "And this section here isn't up to standard." I stared at the nearly pristine walkway. "Brenda, I spent hours on this yesterday. It's as clear as it's going to get without hiring a professional crew. The bylaws require complete removal. I'll give you until end of day." She made a note on her clipboard and walked away, her boots clicking on the concrete I'd just cleared. That evening, after another 2 hours of work and $50 spent on industrial ice melt, I finally satisfied her standards. My back ached, my hands were raw, and I was starting to regret every decision that led me to this neighborhood. 2 days later, it snowed again. 4 inches overnight, followed by freezing rain that turned everything into a skating rink. I was up at 6 in the morning, shoveling and salting, knowing Brenda would be by to inspect. Sure enough, she appeared at 9 sharp. "You missed the 48-hour window," she announced. "The snow started Tuesday evening. It's now Thursday morning. That's violation number 1. "Brenda, I cleared this yesterday. The freezing rain happened overnight. The bylaws state 48 hours from the start of the precipitation event. I'm issuing a formal warning." She handed me an official-looking letter on HOA letterhead. I read the letter in disbelief. It threatened fines starting at $100 for the first violation, doubling for each subsequent offense. "This is ridiculous. I've been maintaining this walkway constantly. The standards are clearly outlined. If you're unable to meet them, perhaps you should consider hiring a service." She turned to leave, then paused. "Oh, and the board meeting is next Tuesday at 7. You might want to attend." That weekend, I did my research. I pulled out every document from closing, reviewed the HOA bylaws cover to cover, and made some interesting discoveries. The section about walkway maintenance was indeed there, buried in paragraph form with no clear delineation of responsibilities. But more interesting was what I found about liability. According to Minnesota state law and the specific language in our HOA documents, The HOA maintained ownership of all common areas, including the walkways. While they could assign maintenance responsibilities to homeowners, they couldn't transfer liability for injuries occurring on HOA-owned property. That liability remained with the association itself. I made copies of everything and attended that Tuesday board meeting. The meeting was held in the community center, a modest building near the park. About 20 residents showed up, most looking as thrilled to be there as I felt. Brenda sat at the head table with 4 other board members. Richard, the vice president who looked perpetually exhausted. Susan, the treasurer who seemed more interested in her phone. Carl, the secretary who was actually taking notes. And Margaret, a member at large who kept nodding at everything Brenda said. After the standard agenda items, Brenda reached my topic. We need to address continued maintenance issues with the Eastern Walkway. Mr. Zimmerman has received a formal warning for failure to maintain proper clearance standards. I raised my hand. I'd like to address that. Brenda's expression showed she wasn't pleased, but protocol required her to let me speak. Go ahead. I stood, holding my folder. I've reviewed the bylaws extensively. While Section 7 assigns maintenance responsibilities, it doesn't address the liability structure for injuries on HOA-owned common areas. According to Minnesota Statute 515B.3102, the HOA maintains liability for injuries on association property, regardless of maintenance assignments. Your point? Brenda asked, her tone sharp. My point is that I'm being held to an impossible standard without proper consideration of the legal implications. The 48-hour window doesn't account for weather fluctuations, and the inspection standards are subjective. I'm proposing the HOA either hire a professional service for all common walkways or revise the bylaws to include reasonable maintenance standards with objective criteria. Richard perked up. That's actually not a bad idea. We've had complaints about other walkways too. Brenda shot him a look that could melt the ice I'd been fighting. We've operated under these bylaws for 15 years without issue. Mr. Zimmerman simply needs to fulfill his obligations like every homeowner before him. Who lived in my house before me? I asked. Susan looked up from her phone. The Hendersons. They moved to Florida. And did they maintain this walkway? An uncomfortable silence filled the room. Finally, Carl checked his notes. According to records, the Hendersons were cited multiple times for walkway maintenance failures. They eventually paid a service to handle it. How much did that service cost them annually? I asked. Around $1,500, Carl replied. I turned to the room. So the HOA expects me to either spend 3 to 4 hours every time it snows, meeting standards that are subjectively judged and enforced with escalating fines, or pay $1,500 a year for a service to maintain property I don't own, but for which the HOA retains legal liability. Does anyone else see a problem with this arrangement? Several residents murmured in agreement. Brenda's face reddened. This is not up for debate. The bylaws are clear. Then I request a formal review of the bylaws at the next meeting, I said, with particular attention to the liability and maintenance standards sections. I'd also like documentation of injury claims filed against the HOA for walkway incidents over the past 5 years. That information is confidential, Brenda snapped. Actually, under Minnesota HOA law, members are entitled to review association records, including insurance claims and incident reports. I'm making a formal request. I'd done my homework. The meeting devolved from there, with Brenda insisting on procedure and several other residents chiming in with their own grievances about HOA enforcement. By the end, Richard had agreed to add a bylaws review to the next meeting's agenda. much to Brenda's obvious displeasure. As I was leaving, an older man approached me. "Vincent, right? I'm Tom, live over on Maple Court. That was impressive in there. Brenda's been running this HOA like her personal fiefdom for years. It's about time someone pushed back." "I just want reasonable standards," I said. "I don't mind doing the work, but the way it's structured now is designed for failure." "Oh, it gets worse," Tom said, lowering his voice. "Last year, she cited the Kowalskis for having their garbage cans visible from the street. Cost them $800 in fines before they installed a privacy fence. Then she cited them for the fence being 6 inches too tall." I shook my head. "How does she keep getting elected president? Most people don't come to meetings. She stacks the votes with her friends." "You should watch your back. She doesn't like being challenged." Tom wasn't wrong. The next snowfall came 3 days later, and Brenda was at my door before I'd even finished my morning coffee. "The walkway needs to be cleared," she announced. I looked outside. A light dusting covered everything, maybe an inch at most. "Brenda, it literally just stopped snowing 20 minutes ago. The 48-hour window hasn't even started." "The walkway is impassable," she insisted. "It's an inch of snow. People can walk through an inch of snow. Someone could slip on powder snow. That's not ice." Her eyes narrowed. "Are you refusing to maintain the walkway?" I took a deep breath, trying to keep my temper in check. "I'm saying that I'll clear it within a reasonable time frame as required by the bylaws. I'm not going to drop everything the second a snowflake falls because you've decided to camp out waiting for me to violate some arbitrary standard. I'll note your refusal in my report." She made a show of writing on her clipboard before leaving. That was when I realized this wasn't about walkway maintenance. This was about control, about Brenda asserting her authority and punishing me for challenging her at the meeting. I'd dealt with people like her before, petty tyrants who derived their entire sense of self-worth from wielding what little power they had over others. I cleared the walkway that afternoon, taking my time, doing a thorough job. I even documented it with photographs, time-stamped and geotagged. If she wanted to play games, I'd make sure I had evidence. The bylaws review meeting was scheduled for late February. In the meantime, winter continued its assault on Rochester, and I continued my battle with the walkway. Every snowfall brought Brenda's inspection, every inspection brought criticism, and every criticism pushed me closer to my breaking point. The final straw came on a Sunday morning in mid-February. We'd had a significant storm the day before, 8 inches of heavy, wet snow followed by sleet. I'd spent 5 hours clearing the walkway on Saturday, using both a shovel and a snowblower I'd finally broken down and purchased. The walkway was pristine when I finished at 7 that evening. Sunday morning, I woke to Brenda pounding on my door at 8. "The walkway is unacceptable," she declared when I answered. "I cleared it yesterday. Everything was perfect. There's ice now. The temperature dropped overnight and the remaining moisture froze. You should have applied more salt." I grabbed my coat and followed her outside. She was right, technically. There was a thin layer of ice in spots where meltwater had refrozen, but calling it unacceptable was a stretch. It was no worse than every other surface in the neighborhood, including the main roads. "Brenda, I can't control the weather. I cleared everything thoroughly yesterday. If moisture refroze overnight, that's not a maintenance failure. The bylaws require the walkway to be safe at all times. This isn't safe." She pointed at a section where ice had formed. "I'm issuing a citation for weather I can't control. For failure to maintain safe conditions. You'll receive the formal notice by mail." She handed me a citation on the spot anyway, already filled out and dated. I stared at the paper. $100 fine. This is harassment. This is enforcement of community standards. If you don't like it, you're welcome to move." She walked away, leaving me standing in the cold holding a citation for an act of God. That afternoon, I made a decision. I pulled out the bylaws again, reading every word carefully, looking for loopholes. What I found was interesting. The bylaws assigned maintenance responsibilities, but they didn't make such maintenance legally mandatory beyond the HOA's enforcement mechanisms. The HOA could fine me, place a lien on my property, or take me to arbitration, but those were all civil matters. And critically, I found the section on liability again. The HOA owned the walkways. The HOA was liable for injuries. The HOA could assign maintenance, but they couldn't escape that fundamental liability. And if they wanted to fine me for not maintaining their property to their subjective standards, well, let them try. But I wasn't going to keep breaking my back for 100 feet of walkway that wasn't even mine. I drafted a formal letter to the HOA board that evening. In it, I stated that I was ceasing all maintenance of the eastern walkway effective immediately, citing the unreasonable enforcement standards and the documented pattern of harassment. I noted that, as the walkway was HOA-owned common area, the HOA retained full liability for its condition regardless of maintenance assignments. I sent the letter certified mail to every board member, then I stopped. No more shoveling, no more salting, no more 3-hour sessions chipping ice. When it snowed, I cleared my own driveway and sidewalk and left the walkway completely untouched. The response was swift. Brenda called me the day she received the letter, her voice shaking with anger. "You can't just refuse to maintain HOA property." "Actually, I can," I said calmly. "You can fine me according to the bylaws, but I'm not required to perform the labor. You can either hire a service or do it yourselves. The bylaws clearly state, the bylaws assign maintenance responsibilities, but they don't create an enforceable mandate. You can pursue civil remedies, which I'm prepared to contest, or you can act like a reasonable HOA and hire a professional service for all common walkways like I proposed at the meeting. This is a violation of community standards. Then enforce it through proper channels. I'll see you at the next board meeting." I hung up before she could respond. The next snowfall came 2 days later. I watched from my window as the walkway slowly disappeared under 3 inches of fresh powder. Brenda appeared around noon, staring at the untouched snow, then glaring at my house. I waved from the window. She pulled out her phone, presumably calling the other board members. By evening, the snow had been trampled by residents walking through, creating an uneven, potentially hazardous surface. The following morning, ice formed over the compressed snow. Brenda posted notices on the community bulletin board warning residents about dangerous conditions on the eastern walkway and announcing it was closed until further notice. The February board meeting was standing room only. Word had spread about my refusal to maintain the walkway, and apparently it had struck a chord with other residents dealing with similar issues. Brenda opened the meeting with her usual efficiency, but her demeanor was different. She was wound tight, her movements sharp, her smile forced. When we reached the bylaws review item, she tried to gloss over it. "In light of recent events, the board has reviewed the walkway maintenance provisions and finds them adequate as written." "I disagree," I said, standing. "And I'm not the only one." A woman I didn't know stood up. "I'm Kelly from Oak Street. My husband and I are responsible for the western walkway, and we've had the same problems. Constant inspections, subjective standards, threats of fines. It's harassment." An older gentleman rose. "Paul, Cherry Drive. I want to know why we're not hiring a professional service for all common areas. My dues are $700 a year. Where's that money going if not to maintain common property? Susan, the treasurer, looked uncomfortable. Most of our budget goes to landscaping and administrative costs. Administrative costs, Paul pressed. We're a 60-home community. What administrative costs? Legal fees, insurance, management. We don't have a management company, Tom interjected, standing. Brenda handles everything herself, which is the root of the problem. She's turned HOA enforcement into a personal crusade. The meeting exploded into argument. Residents shouted over each other, grievances poured out, and Brenda sat at the head table looking like she'd swallowed a lemon. Richard tried to restore order, banging a gavel that nobody paid attention to. Finally, I raised my voice over the chaos. I propose a motion. The HOA hires a professional snow removal service for all common walkways, funded by existing dues. Maintenance assignments are suspended pending a full review and revision of the bylaws by an independent attorney, not the HOA's current counsel, who clearly drafted these provisions to favor maximum enforcement. Second, Kelly called out immediately. Brenda found her voice. This is completely out of order. You can't just under Robert's Rules of Order, which our bylaws state govern meetings, any member can make a motion during new business, Tom said. He was grinning. And it's been seconded. We need a vote. The board hasn't discussed this, Brenda protested. Doesn't matter. Member motion properly seconded. Let's vote. Richard looked at Brenda, then at the room full of angry residents, and made a decision. All in favor, a chorus of ayes filled the room. Opposed. Brenda and Margaret were the only ones. Even Susan and Carl remained silent. Motion carries, Richard announced. Brenda, we'll need to get quotes for snow removal services. Brenda stood abruptly, her chair scraping loudly. This is a mistake. You're all making a huge mistake. She gathered her papers and left, slamming the door behind her. The room sat in stunned silence for a moment, then someone started clapping. It spread until most of the room was applauding. I didn't feel victorious, though. I felt tired and frustrated that it had come to this. Richard adjourned the meeting early, and several residents approached me afterward to shake my hand or share their own HOA horror stories. Kelly and her husband invited me to their place for coffee sometime, as did Tom. It seemed I'd accidentally become the face of an anti-Brenda movement, which wasn't exactly what I'd wanted, but I'd take it. The following week was quiet. No Brenda inspections, no citations, no angry phone calls. The eastern walkway remained snow-covered and icy, with caution signs posted at both ends. Richard sent out an email update stating that the board was obtaining quotes from 3 snow removal services and expected to make a decision within 2 weeks. I thought maybe things would settle down. I should have known better. The trouble started when old Mrs. Henderson from Birch Lane decided to use the eastern walkway despite the closure notices. It was a shortcut to the community mailboxes, and she'd been using it for 20 years. Ice or no ice. She slipped on a section of ice right in front of my house and broke her wrist. The ambulance came, neighbors gathered, and someone called Brenda. By the time the EMTs had Mrs. Henderson loaded up, Brenda was standing on the walkway pointing at my house and talking animatedly to a police officer. I went outside to see what was happening. The officer, a young guy named Daniels according to his nameplate, turned to me. "Are you the homeowner?" "Yes, Vincent Zimmerman." "What's going on?" Brenda spoke before the officer could. "You're responsible for this. Your negligence caused Mrs. Henderson's injury." Officer Daniels held up a hand. "Madam, please, let me handle this." He turned to me. "She says you're responsible for maintaining this walkway and you've been neglecting it." "That's partially true," I said. The HOA bylaws assign maintenance, but I ceased performing that maintenance 3 weeks ago after documenting a pattern of harassment by the HOA president. The walkway is HOA-owned common property, and they've been notified of my position. So you're admitting you let it become dangerous? Brenda demanded. I'm stating that the HOA, as the property owner, is responsible for maintaining their property. I'm a homeowner who is being forced to maintain property I don't own to subjective standards enforced through harassment and excessive fines. Officer Daniels pulled out his notepad. This is a civil matter between you and the HOA. Mrs. Henderson's injury is unfortunate, but from what I can see, the walkway was posted with closure signs. She chose to use it anyway. He looked at Brenda. Is that correct? Brenda hesitated. The signs were posted, but that doesn't absolve him of responsibility. Actually, it probably does, Daniels said. If the HOA owns the property, posted warnings about its condition, and someone chose to ignore those warnings, liability likely falls on the HOA or the individual, not a homeowner who doesn't own the property. You'd need to talk to a lawyer about that, though. He closed his notepad. Like I said, civil matter. I'll file a report about the injury for insurance purposes, but that's it. After he left, Brenda turned to me, her face pale with anger. You did this on purpose. You wanted someone to get hurt. That's insane, I said. I wanted the HOA to hire a professional service like any reasonable association would. You're the one who turned walkway maintenance into a power game. If you'd listened at any point in the past 2 months, none of this would have happened. You'll pay for this. I promise you that. She walked away, pulling out her phone. I went back inside feeling sick. I hadn't wanted anyone to get hurt. Mrs. Henderson was a nice lady who always waved when she saw me. This whole situation had spiraled way out of control. That evening, Tom called me. Hey, wanted to give you a heads up. Brenda's calling everyone, trying to get support for an emergency board meeting to vote on some kind of action against you. What kind of action? She's talking about immediate fines, possibly a special assessment to cover liability. Richard's pushing back, but she's relentless. An emergency meeting requires a majority of board votes, right? Yeah, 3 out of 5. Richard and Carl are against it. Susan and Margaret will vote with Brenda. It's going to come down to whether Susan actually shows up, which she usually doesn't for emergency meetings. This is getting ridiculous. That's an understatement. Listen, I've talked to some other residents. We're considering calling for a special election to remove Brenda from the board. Thought you should know. Would that even work? According to the bylaws, a petition signed by 30% of homeowners can trigger a special election for any board position. We've got a lot of angry people right now. Might be the time. After we hung up, I sat in my living room staring at the snow falling outside. How had moving into what seemed like a nice, quiet neighborhood turned into this mess? All I'd wanted was a decent place to live, not a war with my HOA president. The emergency meeting happened 3 days later, despite Susan showing up and voting against it. Apparently, Margaret had found some obscure bylaw provision allowing emergency meetings with just a 3-vote majority if it concerned immediate safety issues. Brenda was using Mrs. Henderson's injury as justification. The meeting was tense. About 30 residents showed up, roughly split between those supporting Brenda's position and those supporting mine. Brenda came prepared with printed materials, photographs of the icy walkway, and a statement from Mrs. Henderson's daughter about the injury. This situation has created a dangerous precedent, Brenda began, standing at the front of the room like a prosecutor. When homeowners refuse to fulfill their obligations, people get hurt. Mrs. Henderson suffered a broken wrist because Mr. Zimmerman decided the rules didn't apply to him. Kelly stood up. Mrs. Henderson walked past 2 closure signs, and you still haven't addressed why we don't have professional snow removal for common areas. That's being addressed through proper channels, Brenda said. This meeting is about Mr. Zimmerman's refusal to maintain the eastern walkway and the liability that refusal created. The HOA owns the walkway, I said, remaining seated. The HOA bears the liability. That's Minnesota law. I've provided documentation of harassment and unreasonable enforcement. If Mrs. Henderson's injury is anyone's fault, it's the HOA's for not properly maintaining property they own. You were assigned that responsibility. An assignment you can enforce through fines and liens, which I'm prepared to contest, but which doesn't transfer the underlying liability. You keep conflating maintenance assignment with property ownership and legal liability. They're not the same thing. Richard spoke up. Vincent's right about the liability issue. I've consulted with an attorney. The HOA's insurance will cover Mrs. Henderson's injury because it occurred on HOA property. Maintenance assignments don't change that. Brenda's face flushed. So you're taking his side. I'm stating the legal reality. We need to move forward with hiring a professional service and stop this nonsense before someone else gets hurt. I call for a vote, Brenda announced. All in favor of imposing immediate daily fines of $200 on Mr. Zimmerman until the eastern walkway is properly maintained, say aye. You can't do that, Carl protested. That's not how fines work according to our bylaws. There's a progressive structure. Emergency provisions allow the board to impose whatever measures are necessary to address immediate safety concerns. Show me where in the bylaws it says that, Richard demanded. The meeting dissolved into arguments about bylaw interpretations, with Brenda insisting on her authority and Richard pushing back. Eventually, Susan, who'd been silent throughout, spoke up. I've been reviewing the budget. We have enough reserve funds to hire a snow removal service for the rest of the season. Why don't we just do that and table this whole mess? Because it's about principle, Brenda snapped. If we let one homeowner refuse their obligations, everyone will think they can do whatever they want. Maybe our obligations are unreasonable, Tom said. Maybe that's the real problem. The vote Brenda wanted never happened. Richard refused to call it, stating it violated bylaw procedures. The meeting ended with nothing resolved except everyone angrier than before. As I was leaving, a man I didn't recognize approached me. He was in his 50s, wearing an expensive suit. Mr. Zimmerman. I'm James Wellington, attorney. I've been watching this situation with interest. If you're planning to fight the HOA's actions, I'd like to discuss representing you. I appreciate it, but I'm hoping this doesn't go that far. It already has, he said, handing me a card. Mrs. Henderson's daughter is talking about suing the HOA for negligence. When that happens, the HOA will try to shift blame to you through your maintenance assignment. You'll need representation. The officer said liability was on the HOA or Mrs. Henderson. In theory, yes. In practice, insurance companies and lawyers will look for anyone to blame. Your refusal to maintain the walkway, even if legally justified, opens you up to claims. Think about it. He nodded and left. I looked at the card. Wellington and Associates, personal injury and property law. Great. Now I needed to worry about lawsuits too. The next few weeks were surreal. The HOA hired a snow removal service, ending the immediate problem of icy walkways. Mrs. Henderson's daughter did file a lawsuit against the HOA, seeking medical expenses and pain and suffering. And Tom's petition to remove Brenda from the board gained signatures rapidly. Brenda responded by becoming even more aggressive in other areas. She started citing residents for minor violations. Garbage cans left out too long, cars parked on streets overnight, lawn decorations exceeding size limits. It was like she'd decided if she was going down, she'd take everyone with her. I received 3 separate citations in 1 week. Once for my recycling bin being visible from the street 6 hours after collection. Once for having a package on my porch for more than 24 hours. And once for my mailbox post allegedly being faded and requiring repainting. The fines totaled $350. I ignored them all and called James Wellington. We met at his office in downtown Rochester. He reviewed my documentation, the correspondence with the HOA, the timeline of events, and the citations. "This is a clear pattern of harassment and retaliatory enforcement," he said. "We can fight every one of these citations and probably get them dismissed. But more importantly, we can file a counterclaim for harassment and seek an injunction preventing further retaliatory actions." How much is this going to cost me? I'll be honest, litigation isn't cheap. But I think we can settle this quickly once the HOA realizes they are on shaky legal ground. Their insurance company won't want prolonged litigation, especially with the Henderson lawsuit pending. What about that lawsuit? Am I going to get pulled into it? Possibly. The HOA's insurance might try to add you as a defendant to spread liability, but we can fight that. The key facts are in your favor. You documented the harassment, you formally notified the HOA you were ceasing maintenance, and they posted closure signs acknowledging the dangerous condition. I signed the retainer agreement. It felt like admitting defeat, letting a simple neighborhood dispute escalate to lawyers and lawsuits. But Brenda had left me no choice. James filed our response to the citations and a formal complaint against the HOA for harassment within a week. He also sent notice to the HOA's insurance company about the retaliatory enforcement pattern, which apparently got their attention quickly. 2 days after that notice went out, I received a call from the insurance company's lawyer, a woman named Patricia Morrison. "Mr. Zimmerman, I represent the HOA's liability insurance carrier. I'd like to discuss a resolution to the current situation. I'm represented by James Wellington. I'm aware. I've spoken with him. I'm calling because I think we can resolve this without prolonged litigation if everyone acts reasonably. I've been trying to act reasonably since January. Your insured's president doesn't seem interested in reasonable. I understand, and frankly, Mrs. Patterson's actions have created significant liability for the association. We're prepared to make an offer. All pending citations against you are withdrawn. The HOA commits to professional maintenance of all common walkways going forward, and we revise the bylaws to include objective maintenance standards with reasonable enforcement procedures. What about my legal fees? We'll reimburse your attorney fees to date and provide indemnification if you're added as a defendant in the Henderson lawsuit." And Brenda, Patricia hesitated. Mrs. Patterson's status as board president is an internal HOA matter. We can't dictate that. However, we've made clear to the board that continued aggressive enforcement actions will jeopardize coverage. So she stays in power and continues harassing people, just more carefully. I can't comment on that. But I can say that our claims investigation has revealed a pattern of complaints about Mrs. Patterson's enforcement practices. That information has been shared with the board. I talked it over with James. He thought the offer was reasonable and about as good as we'd get without litigation. "The insurance company basically wants this to go away," he explained. "They're worried about the Henderson case and don't want complications. Accepting this offer protects you legally and gets you out of the immediate conflict. But it doesn't solve the real problem." "No, but that's not something a lawsuit can fix. Culture change in an HOA requires the residents to take action. Your role in this is almost done." I accepted the offer. All my citations were formally withdrawn, the HOA committed in writing to professional walkway maintenance, and I signed a release of claims. It felt anticlimactic, like building up to a confrontation that never came, but Tom's petition was still circulating. By early March, he had signatures from 38% of homeowners, well over the required 30%. He submitted it to the board, triggering the special election process. Brenda fought it tooth and nail. She challenged the validity of signatures, questioned the petition format, and tried to delay the election date. Richard overruled her on every point, backed by Carl and Susan. The election was scheduled for late March. In the meantime, winter was finally loosening its grip on Minnesota. The snow melted, the ice disappeared, and the eastern walkway became just another stretch of concrete. The professional service the HOA hired kept everything clear and safe. It turned out that when you paid people whose job was snow removal to remove snow, they did it efficiently without drama. The special election drew the biggest turnout in Pinewood Heights history. 52 of the 60 homeowners showed up or submitted proxy votes. Brenda ran against Kelly's husband Mike, who'd agreed to step up after Kelly convinced him. Brenda's campaign focused on maintaining standards and protecting property values. Mike's focused on reasonable governance and professional management. The vote wasn't even close. Mike won with 68%. Brenda didn't attend the transition meeting. She submitted her resignation from the board entirely, along with a scathing letter about ungrateful neighbors and declining community standards. Margaret resigned with her. The board held emergency elections to fill the positions, and 2 younger residents who'd been vocal about HOA reform won easily. The new board, led by Mike, acted quickly. They hired an attorney to review and revise the entire bylaws document, focusing on objective standards and reasonable enforcement. They established a transparent budget process and quarterly town halls for resident input. And they formally apologized to me and several other residents who'd been subjected to excessive enforcement actions. Mrs. Henderson's lawsuit was settled by the insurance company for $30,000 to cover medical expenses and pain and suffering. I was never added as a defendant. Mrs. Henderson made a full recovery and apologized to me personally for her daughter's overzealousness in pursuing the claim. By May, Pinewood Heights felt like a different community. Spring brought people out to the community park, and I actually got to know my neighbors as people rather than fellow victims of HOA tyranny. Tom and I became friends. Kelly and Mike hosted a neighborhood barbecue where people actually seemed to enjoy themselves. I even saw Brenda once in late May, driving through the neighborhood. She didn't wave, just stared straight ahead like she'd never lived here. Someone told me later she was selling her house and moving to Arizona. I couldn't say I was sorry to hear it. The revised bylaws were approved in June by an overwhelming majority. They included clear maintenance standards with objective criteria, a mediation process before enforcement actions, caps on fine amounts, and provisions for professional management of common areas. Everything I'd wanted from the beginning, but it had taken 6 months of conflict to achieve. Looking back, I wondered if there was a way it could have gone differently. If I'd just paid for a service from the start, maybe none of this would have happened. But then, Brenda would still be president, still enforcing arbitrary standards, still making life miserable for anyone who didn't comply exactly with her vision. Sometimes standing up to petty tyranny means things get worse before they get better. The Eastern Walkway, that 100-foot stretch of concrete that started everything, became a symbol for the community. The new board even installed a bench there with a plaque reading, "Community means working together." I sat on that bench one evening in July, watching the sun set over the park, and felt something I hadn't felt since moving in: peace. The walkway was clear and safe, maintained by professionals who did their job without drama. No more Brenda inspections, no more citations, no more fighting over ice and snow. Tom walked by and stopped to chat. "Beautiful evening," he said. "Yeah, it is. You know, I was thinking about this whole mess. You moved here in January, right?" "Right." "Worst possible time to discover your HOA is run by a tyrant. At least you figured it out quickly." I laughed. "That's one way to look at it. Seriously, though, thanks for not backing down. A lot of people would have just paid the fines and hired a service to avoid confrontation. You standing up to her gave the rest of us permission to do the same. I'm not sure I deserve that much credit. I was just tired of being harassed. Sometimes that's enough. One person saying no can change everything." After Tom left, I stayed on the bench a while longer, thinking about his words. Change rarely comes easily, especially when it challenges someone's sense of control and authority. Brenda had built her identity around being the enforcer, the guardian of standards, the one who kept the neighborhood in line. Losing that had probably felt like losing herself. I almost felt sorry for her. Almost. The rest of that summer was blissfully uneventful. I focused on making my house a home, planting a garden, and actually enjoying the property I'd bought. The new board ran things efficiently and professionally. Community events drew good turnout. People smiled and waved instead of looking nervous about potential violations. In September, I was elected to the board myself, replacing Richard, who decided to step down after years of service. I wasn't sure I wanted the position, but Mike convinced me it was important to have people who understood the importance of reasonable governance. My first meeting as a board member felt surreal. Sitting at that table where I'd argued with Brenda just months ago, now working collaboratively with Mike, Carl, Susan, and 2 new members to make decisions that affected the community. We approved a reasonable budget, discussed upcoming maintenance projects, and handled a complaint about a barking dog with mediation rather than immediate fines. It was boring in the best possible way. No drama, no power games, just people working together to maintain a community. Winter came again, as it always does in Minnesota. The first snowfall in November brought back memories of the previous year. But this time, when I looked out my window at the eastern walkway, I saw a professional crew clearing it efficiently. No Brenda inspections, no citations, no 3-hour sessions chipping ice. I cleared my own driveway and sidewalk, made some coffee, and watched the snow fall in peace. The eastern walkway would be maintained properly. The community would function smoothly. And I could just be a homeowner, living my life without fighting a war over ice and snow. That's what I'd wanted all along. Sometimes you have to fight for the simple pleasure of being left alone. Sometimes standing up to unreasonable authority is the only way to create the space for reasonable people to thrive. The walkway ice that had consumed so much of my time and energy the previous winter became nothing more than a memory, a story I'd tell at neighborhood gatherings. "Remember when Brenda used to inspect everyone's walkways?" someone would say, and we'd all laugh at how absurd it had been. But underneath the laughter was the knowledge that it could happen again if we weren't vigilant. HOAs aren't inherently bad, but they're vulnerable to capture by people who crave control. Our job as residents was to stay engaged, attend meetings, and make sure power never again became concentrated in the hands of someone who'd wield it as a weapon. In December, the new board held a community holiday party in the center. About 40 people showed up, a record. We ate cookies, drank cider, and celebrated another year in Pinewood Heights. Mike gave a short speech thanking everyone for their engagement and participation in making the community stronger. As I stood there, surrounded by neighbors who'd become friends, I realized something important. The fight over the eastern walkway hadn't been about ice or snow or walkway maintenance. It had been about what kind of community we wanted to be. Did we want to live in fear of citations and fines, constantly looking over our shoulders for the next violation? Or did we want to live in a place where reasonable people worked together to maintain a nice neighborhood? We'd chosen the latter, but it hadn't been easy or automatic. It had required conflict, confrontation, and the willingness to stand up to someone who abused their authority. Change never came from everyone being nice and avoiding problems. It came from people caring enough to fight for something better. The eastern walkway remained clear and safe all through that second winter. The professional service did their job without complaint or drama. And I lived in my house, enjoying my neighborhood, grateful that I'd stood up to Brenda when it mattered. Sometimes the battles we fight seem small in the grand scheme of things. Who cares about 100 feet of walkway in a neighborhood in Minnesota? But small battles reflect larger principles: fairness, accountability, the right to be treated reasonably by those in authority. When we let those principles slide in small matters, we create space for tyranny in larger ones. I'd learned that lesson well during my first winter in Pinewood Heights. And as I watched the snow fall outside my window that second December, I was grateful for it, even as I remembered the difficulty of learning it. The community had changed. The HOA had changed, and maybe, in some small way, I'd changed too. I'd become someone willing to fight for what was right, even when it was difficult, even when it meant conflict with my neighbors, even when easier options existed. That was worth a winter of ice and snow and battles with a petty tyrant. That was worth the stress and the lawyers and the meetings and the confrontations. Because at the end of it all, we had a community worth living in, an HOA that served rather than ruled, and a neighborhood where people could just be homeowners without fear. The eastern walkway remained clear. The community remained strong. And I remained grateful that I'd moved to Pinewood Heights, even with all the drama, because it had taught me what really mattered: standing up for what's right, even when it's hard.